The other more generally applicable aspect of the HERO Act is a new section of the labor law, section 27D, that applies to a slightly smaller subset of private employers because you have to have at least 10 employees in New York. Probably most of you that are watching this webinar are with organizations that have at least 10 employees in New York, but if you don't and feel that you never will and aren't interested, you could stop watching the presentation now. Although again, there are a number of questions that will be addressed yet in question and answer, so you may want to stick around for that if nothing else. The covered employers, so 10 or more employees and not a governmental entity, must permit employees to establish and administer a joint labor management workplace safety committee. Now, this is publicly explained various ways, and I can only tell you with certainty what the statute itself says, but I think what this means by permit employees to establish is that if you have employees who want to form a workplace safety committee, then they will be able to form the workplace safety committee. I don't think it means you as an employer have an obligation to go out and tell employees that you want them to form this safety committee, or to go to your employees and say, we have to have a safety committee, so form one. But again, that is only my reading of it at this point. The Department of Labor, again, will be required to issue regulations, and I expect this is one of the numerous issues they will address in those regulations. When we will see those regulations, who knows? This component of the HERO Act is scheduled to take effect November 1st, 2021. So if employees come to you tomorrow and say they're ready to form their workplace safety committee, you're able to allow them to do that, but you do not have to allow them to do that until November 1st, 2021. And I think it would be prudent, if that were your situation, to tell those employees, yeah, we understand that you'd like to do that, and we know about the HERO Act, but it doesn't take effect until November 1st, 2021. And for now, we don't want to go down that road because we don't have all the guidance that we're anticipating from the Department of Labor yet to tell us how to set those up properly. And we don't want to, go through the trouble of having this all set up in a way that we will then have to redo in a few months once we have that guidance. So hopefully you can use that to put people on hold. If, however, you want to move forward, then we're going to talk about the main criteria and what we know based on the statutory language. There's no specific number of people who have to be on these workplace safety committees, but the law is clear that at least 2/3 of them must be non-supervisory employees. Now, here is one area where the legislature didn't really do anybody a favor by putting these two separate sections of the labor law in the same thing that they're calling the HERO Act, because while they did define non-supervisory employee for purposes of the airborne infectious disease provisions, that definition does not actually govern directly anyway the workplace safety committee section of the labor law. So I suspect they meant for the same definition to apply to both sections, but they should have been more careful, and perhaps will be by the time they amend the legislation, more careful to make their definitions cross over. But for now, employee itself is defined in the more traditional sense without the express inclusion of independent contractors, staffing employees, staffing company workers, and the so-called gig economy types of workers that arguably are not employees. So draw the line there, as well as the fact that non-supervisory employees has an undefined meaning for the Workplace Safety Committee statute. Although I suspect that if the legislature doesn't get around to it, then the Department of Labor will come in and use the definition from the other section to explain what they're going to interpret this to mean. Okay, beyond that, each committee must apparently be co-chaired by one representative, each of the employer and the non-supervisory employees. So that means every workplace safety committee will have two co-chairs, one of which has to be a non-supervisory employee. For sake of clarification, I'm assuming the other is a supervisory employee. The complication arises with the next component, where employers, at least based on the amendments, are not going to be required to recognize more than one workplace safety committee per work site. We had the question earlier, what happens if some of your employees are in a union and others are not? That creates the complication in how you're going to make up these workplace safety committees. You could have more than one, but you don't have to. So how is the non-supervisory employee representative going to get chosen as between the union group and the non-union group? We don't know at this point. I suppose it could be majority rules, and perhaps that's what the Department of Labor will tell us, but just to make everyone's life somewhat easier, hopefully they do address that in regulations before November 1st.